Hello, dear audiences. My name is Ömer Ali Girgin, and I am a research assistant in Anadolu University in Faculty of Law. And I am here to introduce you the Introduction to Law book and Unit 4, Chapter 4, Introduction to Administrative Law. Let's begin with the introduction. In this unit, the following topics will be processed: basic principles of Republic of Turkey and her administration, constitutional history of Republic of Turkey, legal framework of Turkish administrative law with its principles. Our first heading is constitutional law in general and also in Turkey. The main subject of constitutional law is the form and main organs of the state, structure and functions of the state organs, and fundamental rights and freedoms. Constitution, on the other hand, is, among other rules, at the heart of the constitutional law. So we understand that the Constitution is a main source for the constitutional law. Constitution is defined as a body of fundamental principles or established precedents according to which a state or other organization is acknowledged to be governed. A constitution is found either with an establishment of a new state or after a war or a revolution. Let's have a look at the history of constitution in Turkey. There are some papers which are related to constitutional papers. So first of them is Senedi İttifak. It's 1808. Gülhane Hattı Hümayunu, or also known with Tanzimat Fermanı, in 1839. Kanuni Esasi, Teşkilat-ı Esasiye Kanunu, the Constitution of 1924, the Constitution of 1961, and the current Constitution of Republic of Turkey is the Constitution of 1982. Basic principles of administrative law. Administrative law hasn't been codified. So we have civil law, as you know. We have criminal law, and these departments of laws are codified, as you know. But administrative law is different than the other departments of law. So here, this one is very important difference between the other departments of law and the administrative law. There exist few exemptions, such as law of planning, law of procurement, and law of expropriation. Thus, development of administrative law is provided mostly by jurisprudence. Principle of rule of law is the most important term for the administrative law. As for the components of the rule of law, let's give some examples. Fundamental rights and freedoms shall be guaranteed by the state. Separation of powers shall be granted. Judicial review of acts, actions, and activities of state shall be granted, including the parliament and the administration. Independency and the impartiality of the courts shall be provided. The acts, actions, and activities of the state shall be done within the framework of laws. Responsibility of the administration shall be granted. The principle of no offense and penalty without law shall be granted, and democracy shall be granted. These were the main points of the concept of the administrative law. And now we are looking at the administration law in Turkey, and after that, organization of administration in Turkey. The central administration and the decentralized administration are the main components of the Turkish administration. Article 123 Section 2 of the Constitution states that the organization and functions of the administration are based on the principle of centralization and decentralization. Under that scheme, central administration consists of central departments and provincial departments, where decentralized administration consists of local administrations and functionally decentralized administrations. The basic principle governing administration in Turkey would be integrity. This means central administration and decentralized administration together considered to be one single unit. How about judicial review of administration in Turkey? There are two types of judicial remedies in Turkish administrative judgment. First of them is action for annulment, and second one is full remedy action. Action for annulment is, we can say, in order for a person to sue administration under action for annulment, he or she has to prove a link between him or herself and the administrative act that amount to an adverse effect on him or her. Requirements of standing has been set out by jurisprudence as personal, actual, and legitimate. On the other hand, let's have a look at the full remedy action. In order for a person to sue administration under full remedy action, he or she has to prove that he or she is directly affected and incurred loss as a result of administrative act, action of, or contract. Full remedy action covers the liability issues of administration. In that sense, liability with fault, service fault, we can say, and liability without fault would be the basis of full remedy action. We have come to the end for this chapter 4, Introduction to Administrative Law. Have a good day. Thank you for listening.